are central to this appeal. We submit that they each, individually, lead to the same conclusion. The judge was both entitled to reason and decide the issues as he did, and right to do so. And those 3 points concern, first, the question of approach, both on the part of the judge and in this court. So what we want to look at is the approach which the judge was required to take, and in fact took, in deciding the issues raised by SocGen's application for a stay on jurisdiction grounds. Look at the nature of the decisions the judge made and at the process by which he reached them. As has already been observed in the course of my learned friend's submissions, this was, at bottom, on ground 1, an evaluative exercise. On ground 2, it was both an exercise of discretion and an evaluative exercise, we would submit, because the notion of strong reasons, the strong reasons, tends to suggest questions of degree, and the way in which the court will look at the evidence is one of evaluation of all factors before the court to decide whether the reason given is strong or not. But we don't need to go that far, because on ground 2, it's plainly, as one sees from Donoghue and Armco and any number of other cases, it's plainly an exercise of discretion in the first place. And in company with that, we're bound to have a look at what the cases say, and there's one case in particular which spells it all out, and your lordships will obviously be very familiar with it, the approach that the Court of Appeal should take to evaluative decisions of the type that the judge made. So that's the first point we want to look at. The second is, and obviously this has been the subject of considerable debate already today, is what we say is the first main problem with the appeal, and this concerns ground 1, the almost exclusive focus on construction of the framework agreements, without attention to how it is said that CCLP ever became bound to the jurisdiction agreement in the 3 later framework agreements. And third, I wish to say something about the other, we put it this way, persistent problem with my learned friend's submissions. And this is a matter of looking at the skeleton, and I don't think we heard anything different this morning. It is a point that Lord Justice Snowden picked up, and it's no less than the fallacy in the assertion that the judge found that all relevant entities, and what my learned friend means by that is all Clifford Chance entities, including CCLP, intended to be bound by the terms of the framework agreements. That alleged, asserted finding on the part of the judge is fundamental to practically everything that my learned friend says in his skeleton, and for that matter, everything he said to your lordships today, and it's simply wrong. Before I go to those 3 points, can we say this, please? In fact, what this appeal appears to have resolved itself into is a challenge to the judge's finding that on the evidence, my clients had the better of the case on the issue of authority. A great part of this morning's discussion was about that. And it's not a surprise to us in a sense that my learned friend was reduced to having to put it that way, because as we submit, we are right, and obviously right, to say that you don't get to questions of construction of the framework agreements until you've established that CCLP LLP was party to them. And as your lordships will see from our skeleton, we found the state of affairs as presented to us a rather odd one, because there was literally, and there is literally nothing in the skeleton argument about authority, let alone any criticism of the judge's assessment of Mr. Perrin's evidence. I wanted just to make a couple of points about that. These are not empty forensic points. During the course of the argument, we searched for the word authority in their skeleton. It appears once in paragraph 34, and I'll come back to that in a moment. We also have recently searched for the word Perrin. And as far as we can see, and it could be that the searching mechanism is not as good as it could be, but Mr. Chapman will correct me if I'm wrong, there's no reference to Perrin, Mr. Perrin, anywhere in Malone and Friends' skeleton argument. Now, your lordships will appreciate what this amounts to. It is simply not open to them on their grounds of appeal, even allowing some latitude by reference to the contents of the skeleton argument, to raise and pursue a challenge to the judge's factual, evaluative findings when it comes to the question of authority. In fact, it goes further than that. And can I ask you, please, to take up the claimant's skeleton, the appellant's skeleton, and look at that paragraph 34, which is on page 109 of tab 9, page 109. And look at the point at which the word authority appears, the only reference to it in this document. There's a point first about the effect of the judge's decision. And this is one of those points, I'll come back to this in a moment, at which it's asserted that the result runs counter to the shared intention of the parties that the judge found them to be. But then we should see this. If and to the extent that CC Europe did not have actual authority to enter into an agreement binding CCLP, itself a surprising conclusion, a failure within a firm's internal arrangements for approving a contract should not result in a client of the firm being left with an agreement of extremely limited value. So there's an assertion that it's a surprising conclusion, which you might have thought, if it had been backed up by anything in the grounds of appeal, or backed up by anything in this document, was a precursor to some proper submissions about the judge's preference or the judge's acceptance of Mr. Perrin's evidence and the consequences that had for the argument in the case. But there is nothing. And what is more, we read the words, if and to the extent that CC Europe did not have actual authority to enter an agreement binding CCLP, as essentially an implicit acceptance that they cannot challenge that. Because you won't find any other reference to the issue of authority anywhere in this document. Their whole argument seems to proceed, and this is one of the puzzles that faced us when we were looking at this. The whole argument seems to proceed on the basis, all right, the judge has found that CC had the better of the argument, that CC Europe did not have authority. Let's proceed from there. And the other aspect of all this that I should show your lordships.
I mean, Mr. Chapman did actually, on his feet, certainly go as far as to say, as I recorded it, that the judge was wrong in accepting Mr. Perrin's evidence.
He did. He did. That is the target. That if it was within the within the four walls of the grounds of appeal and the skeleton argument, that is something we would have to deal with. But it isn't, and there's no criticism or attack anywhere in the skeleton argument founded in the original grounds of appeal on the judge's factual evaluative conclusions on that matter. Indeed, I'm bound to say that if that had been the subject of the permission to appeal application to the Court of Appeal, one can never be certain, but it's very hard to see how or why decision on those grounds, an evaluative decision involving findings of fact, better of the argument on the facts, how permission would ever have been granted. Not really the point, it doesn't matter. All that matters to us is that it is not anywhere within either the grounds of appeal or the skeleton argument. And it goes further than that. If I can take you, please, to page 114 behind the same divider at paragraph 43. Because what we have had over the preceding paragraphs, as your lordships will appreciate, is an attack, a challenge to the judge's construction of the framework agreements. Well, so far as it goes, good and fine if once you've established that CCLP were actually party to this contract. But let's look at how it's concluded and the point that, at any rate, according to this skeleton argument, Soc Gen seek to draw from this. Again, we start with what we've called the fallacy. Having found that there was a common intention for all of the parties to observe the terms of the framework agreements, the judge should have found that the framework agreements were intended to and did bind CCLP, such that when the retainer in relation to the gold dust dispute was entered into, it was subject to the terms of the 2006 framework agreements, as subsequently superseded by the later agreements and thus subject to French law. The reasoning of Lord Justice Males and on the judge's readings, the parties failed to give effect to their common intention, etc. Now, this is not an authority-based attack on the judge's decision. It's not clear what it is, remembering that what it dates back to is the time that the gold dust dispute was entered into and Clifford Chance were first instructed. What it seems to be, but there's simply no factual or evidential basis for it, what it seems to be is a submission that somehow, by some form of conduct, Clifford Chance LLP acceded to the framework agreements, or possibly, I suppose, but again, there's no material that one can see to base this on, that somehow the terms of the framework agreements were incorporated in the otherwise implied retainer of Clifford Chance LLP. Remembering also that none of the judge's findings about the factual basis and existence of the implied retainer are themselves challenged at all. So, if it's right to say, and obviously Maloney makes other points, but it really has boiled down to a case that somehow the judge should not have accepted, should not have treated the evidence as he did, he should not have accepted in the way he did Mr. Perrin's evidence, simply is not within the four walls of this appeal. It's also wrong, and the judge is right in the way he approaches it, but I don't need to go that far on this issue. So from that starting point, what I would like to do is just go, and I'll be able to go through these 3 points more briefly, I think, than I'd expected, particularly because of the emphasis that came to pass in the course of Maloney and Friends submissions. But I do want to say something about the 3 points that I've already adumbrated, and then I want to say a number of specific things about particular submissions that were made to your lordships this morning. Your lordships have a paragraph by paragraph, sometimes line by line, response to everything that is said in the skeleton by Soc Gen as it stands, and I don't want to try and redo that exercise. So first point concerns the nature and content of the evidential test for determining whether there is a jurisdiction agreement binding a party to the proceedings, and moving on from there, the Court of Appeal's approach to a challenge to a first instance judge's application of it. Just stopping there for a moment, like my Lord Justice Phillips, I have a recollection of there being something in some case about the respect to be given to a commercial court judge's approach to issues such as this, but I can't, we haven't off the top of our heads and reduced opportunity to research it, come up with a case, but I'm sure we can. But,
or maybe if you find it after we've concluded today, you can send it through.
So from there, we should go, I would suggest, to the judgment at paragraph 79. That is page 67 of the core bundle, where the judge addresses the evidential test on a challenge to jurisdiction on the basis of a binding jurisdiction agreement. And as the judge goes on to say at the end of that paragraph, this is the result of a good deal of recent learning, recent decisions, particularly in the cases of Brownlee and Goldman Sachs International. In our skeleton, we cite another Court of Appeal authority called Respondents. I'll take your lordships to something a bit closer to our case in a moment. But the test is now well established. It's three limbs. Party relying on the existence of the agreement must supply an evidential basis showing it has the better argument, not much the better argument. If there is an issue of fact about it or some other reason for doubting whether it applies, the court must take a view on the material available if it can reliably do so. Just pausing there, it's certainly not suggested in the skeleton. I don't actually think it was suggested to your lordships today that the judge could not, it may be implicit in what Mr. Chapman was saying, the judge could not reliably take a view on the material available. And then the third limb, which we don't get to in this case, Mr. Chapman seemed to suggest one might do on one aspect of the argument, but in our submission one doesn't. That if no reliable assessment can be found, there's a good arguable case for the existence of the agreement if there's a plausible, albeit contested, evidential basis for it. Now, naturally enough, that summary of the principles is not challenged by Soc Gen. In fact, the required test, the judge's application of it, and its elements, including the question of whether or not there is who has the better argument, is not referred to at all that I can recall in the Learning Friends skeleton. And there may well be a reason for that. I'm not suggesting anything underhand on the Learning Friends part. But the fact is that reference to the test and the judge's application of it would expose two basic problems with Soc Gen's primary case in this appeal. Because first, the reference to the test, and especially limb 1 of the test, is a simple and obvious reminder that Soc Gen must deal with the question, the issue of, quotes, the existence of the agreement. And that, I'm bound to say, is a necessity which Soc Gen either ignore, at any rate looking at their skeleton, or gloss over. I say gloss over because of the brief reference that one gets right at the end of the construction arguments in paragraph 43 to how they say, in the briefest, skimpiest terms, CCLLP became bound. And obviously, one needs to address those issues on any logical basis before issues of construction are considered. And second, reference to the test reminds us all of a second factor relevant to this case, and I'm looking here at limb 2, that the test requires, and quotes, evaluative, close quotes, approach. When the cases provide that a judge must take a view on the material available, again, it not being suggested that he can't, the judge couldn't do so reliably. What that's requiring the judge to do is to evaluate all the evidence, rather more than doing the best he can, but to take account of all the materials before him and reach an overall view on the issue of fact he's being asked to consider. And of course, that's exactly what the judge did when it came to his decision that my clients have the better of the argument that CCLP were not bound by any of the framework agreements. I entirely understand what was said to Mr. Chapman earlier, that questions of construction in this court raise different issues. But this isn't a question of construction, it's an issue of fact as to whether or not the evidence is sufficient to establish that SocGen have the better of the argument that there exists a jurisdiction agreement. Perhaps the most useful case when one's reviewing the question of approaches, both by the first instance court and the Court of Appeal, is the case, one of the cases that's referred to by Mr. Justice Henshaw in that paragraph. It's the case of Kaiser Aislamientos, and it's reported in the weeklies, and it appears in the supplementary appeal bundle at tab 1, and a few points about it. If we can see the picture, see what the case was about from the head note. And I don't propose to read it out. The facts, relevant facts for present purposes are quite simple. The point being that the principles I've just outlined are examined and applied in the specific context of an application for a stay on jurisdiction grounds. So this was a case in which the claimant brought claims against 4 foreign defendants seeking to rely on an English exclusive jurisdiction clause. It contended that the contract had been concluded by the first and second defendants as agents for the third and fourth defendant, and that therefore they were also bound by the jurisdiction clause. And for your Lordship's note, you will find that at letters C and D in the head note on page 3 of the supplementary appeal bundle. Then the third and fourth defendants challenged jurisdiction on the ground that the claimant had not shown a good arguable case that they were bound by the exclusive jurisdiction clause. The judge granted that application, holding against the third defendant that the claimant had a good arguable case, but had not shown the better of the shown that it had the better of the argument, and as against the fourth defendant that the claimant did not even have a good arguable case. And one again sees that in the head note at letter E. The Court of Appeal dismissed the appeal, although on the way there they criticised and they held that the judge's approach was wrong in at least one respect, which was to treat the process of determining that it was a good arguable case and then who had the better of the argument as separate stages. But the Court of Appeal then held that the substance of the judge's approach and reasoning was correct and that there was no reason to upset the decision made below. But if one looks, please, at paragraph 70 of the judgment, and this is the judgment of Lord Justice Green, at page 22, you don't need to look at any of this in any detail because it's reflected in those passages in paragraph 79 of the of Mr. Justice Henshaw judgment in this case that I've already taken you to. First, he explains where the law has got to on the question of the evidential test by reference to Brownlee and Goldman Sachs. And then he discusses at 73 and following where the test now stands. It is worth looking, though, and I've drawn your Lordship's attention to what Lim 2 amounts to, taking a view on the material available, it is worth looking at paragraph 78 on page 24, not least because this answers or goes some way to answering one of the points that Mr. Chapman made this morning, which is to the effect, well, of course, Clifford Chance could have produced more evidence. Now, as I say, none of that should arise because of the absence of challenge, but it is important, we submit, to be able to put what Mr. Chapman was saying this morning and what we see in his skeleton in context, and it explains what Lim 2 is all about. Could I invite the court, rather than me read it straight through, could I invite the court just to read paragraph 78 to themselves? And we say that that helps to explain and justify that the approach that the judge took in this case. Again, not being suggested that he couldn't reliably undertake this exercise. He looked at all the evidence. It's not suggested he left any of the evidence, or the submissions for that matter, out, and he took a view. He came to a conclusion. Then what one sees, if one goes, please, to paragraph 93 on page 28. Yet another, I say yet another because these strictures, these statements of principles have cropped up in a number of cases over the last 20 years or so, in particular since the Arab Insurance Group decision of Lord Justice Clark. He then explains and summarises the principles that apply to the Court of Appeals approach to an evaluative decision. And as your lordships will be very familiar with that, he cites the long passage from Todd and Adam and refers over the page at paragraph 97 to the Arab Insurance Group case. And those are all principles that we rely on here. Paragraph 99, he concludes, in this case, the facts are on any view complex. The task of the judge was to weave through a complex body of evidence, some of which was incomplete and or inconsistent. Claimants' arguments were based upon inferences drawn from circumstantial evidence. There was no piece of evidence that the claimant could point to which unequivocally showed that A21 or Ezion were undisclosed principles. The judge has with care set out his findings on the evidence. He addressed the strengths and weaknesses of each piece of evidence and set out the inferences and conclusions that he drew. He demonstrated an exercise of judgment in addressing evidential disputes, which was pragmatic and sensible, and which this court should be slow to interfere with. I can see no basis for interfering with his conclusions on the facts which were well within the margin of that which was proper. The judge applied what, following Goldman Sachs, would be described as a Lim 2 test. In other words, equating a Lim 2 test with an evaluative approach. This case, if anything, is a fortiori, this case that we're dealing with today, because this was not a case in which there were clashes of witness testimony, witness evidence. All the evidence as to what actually happened, it wasn't just Mr. Perrin's evidence, there was also evidence from Mr. Hewitson by reference to documents at what had happened so far as fees and the like were concerned at the outset of the retainer. And then to back up what Lord Justice Green says, and we can see Lord Justice Davis at page 36, paragraph 119. in fact it's paragraph 123 I should take you to. There is no proper basis for the appellate court interfering with the judge's appraisal of the evidence on such an issue. In the ordinary way, the appellate court in cases of this kind will not interfere with the judge's decision on such an issue unless there's been a material error in the legal approach adopted, or a failure to take into account material facts, or taking into account immaterial facts, or a demonstrable misunderstanding, or an evaluation of the evidence which is so unreasonable as to transcend the ordinary margin of appreciation available to a first instance judge evaluating evidence. There was ultimately no such error here. Now, if one tries to run through, unless the court wishes me to, I'm not going to do it, but if one tries to run through the catalogue of, as it were, available criticisms that might lead to a court interfering with an evaluative judgment, material error in the legal approach, failure to take account material facts, one cannot, with respect, all due respect to Mr. Chapman, one cannot find, frankly, a single example of that here. What one does have, he has putting aside the attack on the challenge to Mr. Perrin's evidence, as we read the skeleton, there were essentially two bases of challenge. One was inconsistency, judge's ultimate findings inconsistent with what he, and I'll be coming to this later, what he found, it was said, the parties to intend. Now, if he really had found that Clifford Chance LLP was one of those parties who did intend that they and all other CC entities should be bound, we would be perhaps in a different world. But he did not find that. So that ground of challenge fails. And the other, very broadly based ground of challenge, as we read it from the skeleton argument, is the commercial implications. And there's a great deal of stuff about about the probabilities and improbabilities and matters of that sort. Now, all that amounts to, when we know that the judge took account of all the evidence and took account of all the submissions that were made to him, that is no more than an invitation to this court to differ in their evaluation, respective weight to be given to aspects of the evidence. And that is not something that's open to the appellants, on the principles we've been looking at, to ask the court to do. Moving on from there, please.
Is this appeal really an appeal against a finding of fact? I mean, I know you're saying it's an evaluation. I mean, my understanding is that you have sort of three types of appeals. One, that the law was wrong. You got the law wrong. A different type of appeal is where the judge had the discretion to exercise, and it's that he exercised the discretion having regard to the wrong factors, or failed to take into account the right factors, or just basically went off the scale and exercised it in a way that no reasonable judge could. The evaluative exercise is normally where the judge has a range of factors that he has to take into account to arrive at a result, such as what is the best course of action, or is a legal test met on one of a number of factors. Isn't here the question is really, was there authority or wasn't there? Is that not just a fact-finding exercise as opposed to an evaluative exercise?
Well, it may be, and I can tell you this is a debate I've been having with my junior as to which
one of you
as to which one actually plumps for. Now, I think I'd say two things about that. I'm certainly sympathetic to the view that this is essentially a challenge to a factual finding, albeit an interlocutory one. The fact is that most of the authority on factual findings and challenges to them on appeal tend to focus on findings following a trial, when the judge has heard oral evidence. The second thing I'd say about it is to remind us of what Lord Justice Green says in the Kiefer case, if we go back to paragraph 99, what the judge did in that case was to look at all the evidence, weigh it all up, and come to factual conclusions. And Lord Justice Green appears to treat that as an evaluative exercise, similar to an exercise of discretion. If you like, the two things could be seen as being tied together. When Lord Justice Green says, I can see no basis for interfering with his conclusions on the facts, which were well within the margin of that which was proper. So, my lord, I'm bound to say, I would have thought we are entitled to say one or both of two things. That it is a challenge to factual findings that have been made by the judge, albeit, and I suppose this is the third thing I should have said, of weighing up who has the better of the argument.
Yeah, that's an evaluation.
And that is an evaluation.
That's an evaluation. Who's
Evaluative
got the better of the argument. But underlying it are determinations on the evidence as to, is there reason to believe that Mr. Perrin, for example, was unreliable.
I agree with that, my lord. But we don't need to go. We don't actually need to go that far. When I've been describing it as an evaluative judgment, it took me a bit of time to get there. That's built into the better argument test. And my lord, I can deal with with the next element of this quite quickly. I'm still on point one. It's not just a question of there being no challenge to critical parts of the evidence in the court documents, but that the evidential material as to the making of the agreement all goes the other way. I've already drawn attention to the fact that there now seem to be, and in fact there do seem to be below, and one sees that reflected in the judgment, two ways in which at various times Soc Gen have put their case on the existence of the agreement. One is authority, and that came to the fore today, but also took you to the passage at paragraph 43 of the judgment, looking back earlier in the story to the time that the Goldman, the time that the Gold Dust dispute started and Clifford Chance were retained, the idea that somehow Clifford Chance LLP acceded to or entered into a contract in which the terms of the framework agreement were somehow incorporated. So there have been two different ways of putting it. And the judge deals with both. One sees on the authority issue, I'm not going to turn it up, you all looked at it this morning, paragraphs 105 to 108, 103 to 108. He deals fairly and squarely with the evidence, he weighs it up and comes to a conclusion. But even on that secondary way of putting the case, that is also dealt with by the judge, and that's at page 69 of the bundle, paragraph 86, and he deals with it head on, fair and square. Soc Gen did submit, however, that CCLLP became a party to the 2006 framework agreement by conduct when it accepted instructions from Soc Gen and began to charge fees consistent with the terms of that framework agreement. So the judge then deals with that absolutely head on, paragraphs 87 and following. And again, beyond that rather thin passage in paragraph 43 of my learned friend's skeleton argument, there is no challenge. And what's said in paragraph 43 cannot possibly amount to a reasoned challenge either to the judge's approach or, for that matter, to the substance of what he found. So, my lord, that's all I really wanted to say about respective approaches. Both approach below, see paragraph 79 of the judgment, and the approach that the Court of Appeal is obliged to take to findings of the type that the judge has made. So I wanted to move from there, please, to the point we make time and time again in our skeleton. What one can fairly be described, we would say, as the confusion at the centre of SocGen's argument, the almost exclusive focus on construction of the framework agreements, rather than how CC LLP is said to have become contractually bound by the jurisdiction clause in the framework agreements. That morphed to an extent in the argument, necessarily because my friend was being taxed on the question of how you could say that there was an agreement, into the framework agreements being, if you like, a piece of evidence that go to the factual probabilities in the case. In other words, well, here's what Clifford Chance Europe have written. I'm bound to, it's hardly like to have happened, unless, except with the authority of Clifford Chance LLP. That simply, that obviously, as we've been discussing, is a theme to the appeal which has emerged very late in the day, emerged today. The confusion, of course, as between, that's evident in the skeleton argument, remains. Now, I don't need to labour this. My Lord Justice Snowden made a point about some basic elements of English law. So, the standard approach in English law to a question of whether and in what respects a legal person is bound by a contract and bound by a provision in that contract, it has two basic stages. You first ask and answer the question of whether the person has made the contract in question, and second, if the answer is yes, you decide what the contract provides for and means and what the person is bound to do or not to do. That hardly needs saying, but it's an expression of the basic principle of privity of contract, which is not addressed in any way that we can see in my learned friend's skeleton. And again, to state the blindingly obvious, the taking of the two-stage approach is most obviously necessary in the case of a written contract, when the person in question has not signed the contract and is not identified as a party to the contract by its language. And as I say, that state of affairs engages the basic principle of privity of contract, which is not something addressed by my learned friend in their skeleton, or not, if I may say so, successfully addressed before your lordships this morning. Not least because it is rarely straightforward to establish that a non-party is bound by a written contract deliberately made between others. And the evidential and legal burden in such a case is very much on the person asserting as much to prove it. And in the present case, as we've already been discussing, to satisfy the court that it has, quotes, the better argument. And these are, again, I'm minded to apologise, these are almost legally basic propositions. I should go on to say, because I must, that SocGen does not suggest that French law, to the extent it applies, is any different or more generous to their argument than English law. It would be surprising if it was, given the basic, simple nature of the two propositions, or the process that has to be undertaken. Was there a contract to which the legal person in question was a party? If so, what does the contract mean?
Can I just pick up on one thing? I think you referred to a question about whether non-parties were bound. But I would have thought that the wording of the 2012 agreement, Clifford Chance LLP Europe, acting in its own name and on behalf of all officers of Clifford Chance LLP, etc., if it had authority to say that,
Yes.
then Clifford Chance LLP would be a party.
We'd be in a different. We'd be in a different world.
So it's not a question of whether a non-party is bound. It's a question of whether it's a party.
I think we could go around in circles. The way I would put it is, you've got Clifford Chance. The only party which has signed the contract, is Clifford Chance Europe. There is then a burden. There is then, if the argument is to succeed, an obligation on the party who's saying another party is bound to it to point to why. Now, their task is immeasurably easier as a starting point if you've got a statement to that effect in the contract itself. You then need to go on and ask the further question, which is the one that was addressed in the evidence and so on and so forth, of whether or not there was actual or apparent authority to enter into it. So I don't really think I differ from your lordship on that.
I mean, as I understand it, the words whether somebody is a party to a contract and whether somebody is bound by a contract are the same. There's not one with the other. I mean, you're not bound by a contract unless you are a party to it.
That's the essential submission. I should say this.
But so you know, the real question, whichever way you phrase it, is not what does the contract mean. It's just who are the parties to it, who's bound by it. And as I understand it, what Mr. Chapman says is, look, if one of the parties that is indisputably bound by the contract because their name appears on it purports to have contracted on behalf as agent for somebody else, and he's a lawyer who ought to know what he's doing, it's a piece of evidence to suggest that actually he might have that authority. You'd be perhaps more likely to assume that he would only make that statement if he did indeed have the authority, which is why I think he says the judge ought to have disregarded Mr. Perrin's evidence, or at least found that the better argument was that Mr. Perrin was wrong and that Soc Gen were right as to the actual authority point.
Indeed. That's I will understand Mr. Chapman to be saying, and I understand him to be putting it before your lordships. I touched on this a minute or two ago as a piece of evidence to be weighed in the balance, and the judge deals with it. The judge deals with the evidence, and he finds, looking at Mr. Perrin, that Clifford Chance had the better of the argument. I should say this as well, though, on this point. Finding that, and the judge deals with this, finding that Clifford Chance in some way became bound or a party to the agreement by agency or otherwise, still doesn't deal with the further point the judge went on to deal with, which is whether or not parties other than CC Europe are bound by the jurisdiction clause.
Yeah.
Which is a yet further question.
In relation to any separate retainer they enter.
In relation to any separate retainer, but the judge does find that, as I recall, even if Clifford Chance could be regarded as a party to the 2012-2015 agreement, the phrase "on behalf of," the wording used, he doesn't read as Clifford Chance accepting jurisdiction over the, I'm sorry, I'm behind your lordship's point, jurisdiction over the disputes arising out of the original retainer. Paragraph 107.
Yeah.
Sorry, my lord, I was slow there. I didn't pick up on your lordship's point.
But I think that the force of Mr. Chapman's point, and I think it's important and recognises it's a strong point, is that where a party, a client, is contracting with, in broad terms, the Clifford Chance global firm, in the sense that they are contracting with an entity, their local entity, who says it's acting on behalf of the firm or all of the constituent firms, and it makes provision for how how dealings with particular offices will be charged, etc., and rates, that that there is a strong presumption that the local office, local firm, when it says it has the authority of the other firms, does in fact do so, and so that the evidential burden very much shifts to CC to demonstrate that that was an incorrect statement.
Well, it may do, my lord, and that's how we addressed it. As soon as the question of authority was raised, as it was in Mr. Fowell's witness statement, we put in the evidence of Mr. Perrin.
I think that the question, I suppose, and the question in addressing this argument, whether it's technically a ground of appeal or not might be a different question, but as far as the argument advanced today was concerned, the big issue is, did the judge accept and give sufficient weight to the strength of the case which arises from what was said in that agreement? I think what it comes down to is Mr. Chapman says that the judge didn't give full force and effect to the rather the very strong wording of the agreement and the rather extraordinary proposition that CCLLP, despite being described as bound, wasn't in fact bound.
That's what Mr. Chapman says.
Yes. And where does the judge, in his judgment, recognise, as it were, the starting point, that the rather clear-cut starting point in the 2012 framework?
Well, he starts on the subject at paragraphs 100 and 101 of the judgment, page 72.
Yes.
Where he says, new development, email evidence indicates that wording originated in a proposed amendment put forward by CC Europe, with his point about construing against its maker. And the new provision gives rise to two questions. And he identifies the questions correctly. So, and the two questions that he identifies are very much require, and certainly the first question inevitably requires answering by us. He's recognising that it requires to be answered by CCLLP. And so what he then does in paragraph 103 is set out Mr. Perrin's evidence, and at 104 he deals with the points that may be made in SocGen's favour. So if one looks at the second sentence, he says, in addition, it might be said in SocGen's favour that A, the fact that CC Europe stated in the framework agreements that it was acting on behalf of CCLP in itself constitutes evidence that CCLP had CCLP's authority, and the fact that CCLP subsequently abided by the fee maxima set out in the 2012 agreement is evidence that it was aware of that agreement, and so on. And then at the start of the next page, so paragraph, he says, however, these points have to be weighed against Mr. Perrin's evidence, which is the only direct evidence on the point.
Yeah.
So he is facing up to the argument that was being put. And of course, and essentially these were the points that were being made by Mr. Chapman below. And this is the way in which the judge deals with them. Again, one also cannot get away from the fact that that doesn't itself impinge on the likelihood or otherwise that Clifford Chance was signing up to a jurisdiction clause that required all disputes under whatever retainer, in whatever context and geographical location it might be entered into, to be decided in Paris.
I mean, in paragraph 105, in the just at the end of the bit you did read, He also says he has to take Mr. Perrin's evidence. Sorry, these points have to be weighed against Mr. Perrin's evidence, which is the only direct evidence on the point, and in the context of inherent probabilities. I mean, what he doesn't perhaps say is that one of the inherent probabilities that he took into account was that Mr. Worley wouldn't have, as a lawyer, wouldn't have stated that he had authority on behalf of the other Clifford Chance entities when he didn't. I mean, that's what he says in paragraph in the 2012 agreement that we looked at contains, effectively a statement at the start that he's acting. Europe is acting as agent and authorised on behalf of the others, and he signs it.
That's essentially the point, that if one goes to paragraph 104, the judge is making it little a. In addition, it might be said in SocGen's favour that a, the fact that CC Europe stated in the framework agreement that it was acting on behalf of GCLLP. Now that can't be anything more than a condensed way of saying that those who signed the framework agreement, so Mr. Clifford Chance Europe, Mr. Worley.
I think what Mr. Chapman's argument really comes down to is I think he would probably say that the words, in addition, it might be said in SocGen's favour, drastically understates the weight that might be put on the fact that a managing partner of CC Europe said that he had the authority of the other CC entities to enter the agreement.
Well, with respect, Lords, that would not be the right way of looking at this appeal, because that is, as we see it at any rate, that would be an invitation to this court to differ from an experienced commercial court judge in the way in which he was weighing up all the evidence in front of him.
I understand that. I'm just trying to
I
get
understand.
your response to what I understand is Mr. Chapman's strongest way he puts it.
I understand it as well, my Lord. I think that I will be returning to bits of that point as we go forward, but you have our answers to that.
You might say the third sentence of paragraph 105 is designed to take the sting out of the point.
Yes. Well,
Gives an alternative. Was he right to do that?
well, we submit yes. Now, your lordships will see for themselves, I'm still on my second main point, the way in which the judge treats the issues and works his way chronologically through what happened, starting with the implied retainer, detailed treatment of the evidence, then dealing with the question of whether CCLLP became a party and so on. I'd be no more, if I were to labour those paragraphs of the judgment, I'd be doing no more than inviting your lordships to read the judgment and see the way in which the judge works through this stage by stage in an entirely conventional and we submit correct way. And what it ultimately comes down to, at any rate on the face of the skeleton, although we were back on authority subjects this morning, is that passage in paragraph 43, which is the bold assertion of an entry into the Goldas retainer. CCLLP became bound, and we submit that there's no evidence to support that proposition of how it is said. And this is back in 2008. Clifford Chance LLP consented to be bound by the terms of the framework agreements or otherwise acceded to them. No principle of English law or French law cited as to how there might have been that mechanism and how it might have taken effect.
Well, as for that, as I understand it, you accept an implied retainer came into force.
We do.
And so what are the options for the terms of that retainer? It seems to me that at least one option is that the implied retainer was on the terms of the existing framework agreement.
That is an option. it is an option. We've been puzzling over the different ways in which it might be put, that point, and the two different ways it might be put is that in some way CCLP, simply by entering into the retainer, acceded to being bound by the framework agreements, or, which is saying much the same thing, in some way the framework agreements were incorporated in the retainer.
Or simply an implied retainer on the terms of the framework agreement.
But of course, but that is all subject to there being evidence of what the background to the making of the retainer actually was. And that is evidence that would be within Clifford Chance, within SocGen's possession. There is no evidence. There's no evidence at all to the effect that the framework agreements and the extent to which they did or did not bind Clifford Chance were referred to at the time of the making of the original retainer. And again, we come up against the judge's own findings on the evidence, he deals with it in some detail, as to there being an implied retainer governed by English law. Now, he doesn't make any finding at all because he couldn't, because there was no evidence that in some way, by some means, the framework agreements and their terms were incorporated in into the implied retainer.
And yet
then, of course, he goes on to deal with the question of, even if they were, was Clifford Chance agreeing to submit to French jurisdiction?
Yes. But we know that Clifford Chance did thereafter comply with the terms of the framework agreement in operating the implied retainer.
Well, again, two things about that. That was obviously discussed this morning. The approach is that mere consistency is not enough for these purposes.
Did you manage to find any authority for that? I mean, I confidently asserted that this morning without the benefit.
Which seemed to be accepted by Mr. Chapman.
Yes, I know,
we can
but
have a look.
I do have a recollection that there is some authority that says if you're looking for a contract by conduct, the actions have to be exclusively referable to the existence of a contract, and it's not enough if there's another alternative explanation for them. But I confess I just can't remember where it comes from. I've heard it. So.
What's going through my mind is Marks and Spencer's and Baird text. I don't know. I can't.
Well, I mean, it seems to be implicit in what the judge said at 106, because in the second sentence, because he said the fact that CCLP subsequently abided by the agreed rates is not sufficient, since it's equally consistent with simply having lived up to the undertaking. So that may be a very specific factual point, but he seems to be contrasting something with, or to say that if you're simply doing something that's consistent, and that's an explanation as to why, and there's an explanation as to why you did it, which is other than the fact you're a contracting party, i.e. that CCLP wanted to live up to the undertaking given to SocGen by Europe, then that rules out drawing the inference that they're actually a party, that there's a contract.
And again, it's a question of the judge taking a view and deciding who has the better of the argument. So he takes account of all these factors, of all these elements of the evidence, and reaches a view as he was bound to do.
Mr. Chancellor, you've shown us I think there were three ways that were canvassed below as to how the contracts that CCLP might be part of the contracts. The first was a discussion about transfer of business, which didn't go anywhere because there wasn't any evidence. The second was it exceeded them by conduct, rejected at 86, 87. The third was the agency point. That's it. So the fourth point being put mentioned by my Lord Justice Phillips was a different contract, the implied retainer when CCLP were instructed an implied retainer on the terms of the framework agreements. Was that ever advanced as a possibility?
But personally, I'm not sure I would have seen that as any different from the, as it were, joinder by conduct.
Because it would be implied by conduct in a sense.
Would be implied by conduct. We simply didn't have any evidence, and the evidence was there would have been there to be introduced by Soc Gen if there was any such evidence.
No.
So I wanted to say something before we break. I can deal with this quite quickly. Is the third of our overarching points, what I've called the fallacy. And this needs to be traced through the judgment, starting at paragraph, I'm sorry, not judgment, this needs to be traced through the learned friend's skeleton argument, starting at paragraph 3 on page 98. Soc Gen contends that the judge erred in finding that 1, even though the terms in a series of framework agreements were intended to be applied to all Clifford Chance entities worldwide, as a matter of construction only CC Europe and was bound by the terms of the framework agreements. Now, again, partly true, but doesn't help. It is correct, and we will come back to this, that at paragraph 87 of the judgment, it's page 69 in the core bundle, the judge says, it is true that the 2003 and 2006 framework agreements set out principles and procedures that were evidently intended to be applied to work done for Soc Gen entities by Clifford Chance entities across the world. But of course, taking that statement as its background and looking at what was said in paragraph 3 of the skeleton, it simply, and this is the point Lord Justice Snowden was making this morning, it begs obvious questions which are not in fact answered. Whose intention? How was it CCLLP's intention when CCLP, looking here, the judge's statement concerns the 2003 and 2006 framework agreements, when CCLP was not a party to the contract and didn't sign it. And then in their skeleton, Soc Gen follow this up at paragraph 12. Soc Gen relies on the following express terms of the 2003 framework agreement as demonstrating a common intention that not only CC Europe but also all other CC entities worldwide would be bound. So that again begs the same questions. Whose common intention? And then we see the argument fully presented, and then it recurs throughout the skeleton at paragraph 21 on page 105. Paragraph 21, the judge found that there was a common intention shared by Soc Gen entities and Clifford Chance entities that they would abide by the terms of the framework agreements. And then we see the passage I just took your lordships to, but the judge found that CCLP was nevertheless not bound by the 2003 and 2006 framework agreement. Your lordships will have a pretty simple point. The judge did not find that there was a common intention shared by Soc Gen entities and all Clifford Chance entities. They would abide by the terms of the framework agreements. He only found that there was evidence of the parties and signatories to the framework agreements having or sharing that intention. And that finding is simply not made at paragraph 87, and one knows it isn't if one reads on into paragraph 87. it is obvious from the sentences which follow, because the judge there reasons and concludes that the language of the framework agreements does not support an argument that all CC entities were intended to be found. And of course, a conclusion, or rather an assertion that that is what the judge found or held, is entirely contrary, and it's unlikely to be a trap that this judge would have, or any judge would have fallen into, is entirely contrary to the judge's overall conclusion that CCLP were not bound for all the reasons that he then goes on to give. And all I really need to do is just to remind your lordships, because when your lordships are reviewing my friend's skeleton, you will see that this comes up at numerous points in the remainder of the judgment. Paragraph 32, page 108, I'll just give you the wording, notwithstanding his finding, etc. Paragraph 33, page 109, if, as the judge found, ... Paragraph 34, page 109, runs counter to the shared intention of the parties as the judge found to be. Paragraph 35, subparagraph 2, page 110, the common intention of the parties as he found it. Paragraph 38, page 111, despite it being intended.
I think we've got the point.
Oh, of course. Anyway, your lordship, I was just giving your lordship the list. One also finds that in paragraphs 39 and 43. Now, my lord, what remains for me to do, there are one or two other points that were made this morning by my friend that I do need to respond to, but I would hope to complete those within a half an hour.
You've got to do ground 2 as well.
And including ground 2.
Great. We'll break for 5 minutes now.
Thank you.
Has been following it so closely that he has been reacting to how it's going for us. That's quite sweet. It's very sweet. I mean, that's the point you were making, isn't it?
Yes. Yeah. It's a fundamentally different point, and therefore the point that's being made against us doesn't hold.
I'm not sure there's much more to be said, actually.
No, there isn't. So on the consistent point, the chitty deals with paragraph 4036, and it cites Avonwick Holdings.
Right, fine.
Which
And have
decision,
we got anything on the commercial courts point or not?
not yet, no.
Right, fine.
And that's the decision of Pick and J. The payment, not enough is harsh.
So just do yeah,
Okay, and how do I get to the text?
sit you down for the rest of the day.
Oh, yeah, fine.
The idea that so just in case that's
Yeah.
saying they would do it.
Oh, thank you.
So, but can I have the machine?
If you want to get this is the press that you'll
Press what?
press that one to get Pick. Just pass it back to you.
Court riser table.
So I just say, do finish off ground one, but do allow yourself enough time to deal with ground two.
I certainly will. If I could add something on the implied retainer analysis. In other words, the idea that the implied retainer was on the terms of the framework agreement. There are two additional points I'd make. I may have made one of those already, but just to be clear, that's not what the judge found. He found the implied retainer, and there is no challenge to his findings about the retainer that somehow seeks to say, well, you have to incorporate into its terms the framework agreement. And we do submit, and this is a point of general importance right across the piece. As to the terms of an implied retainer, we submit that it is thoroughly implausible that Clifford Chance in London, being instructed in relation to a piece of litigation in London governed by English law, would have agreed to conduct that litigation by reference to a retainer governed by French law, and although no such jurisdiction clause was in play in 2008, with a French exclusive jurisdiction clause. Obviously, that reminds us of the further difficulty that my friend faces in his reliance on the 2012 and 2015 law and French law and jurisdiction clauses is the judge's point about on the Soc Gen's case, the change of horses in midstream. In other words, something that was on the face of it had no jurisdiction clause is suddenly landed with one. And what's more, what is on its face, as the judge found, or would have been, a retainer governed by English law back in 2008 suddenly becomes governed by French law. The other point, just to pick up, Justice Snowden's point about consistency and what is needed for evidence of that sort to contribute to a finding of the making of a contract. Mr. McWilliams has identified a passage in Chitty at paragraph 4-036, citing a case called Avonwick Holdings and Azidio, 2020 EWHC 1844, at paragraphs 702 and 703. Don't worry. I've read it, my lord. I can read it out to your lordships, but I'm sure your lordships will be able to find it. Decision of Mr. Justice Picken. At 703, lastly, as to part performance, as previously explained, this would need to be consistent with there being an agreement and must evidence the intention of both parties to be bound by that agreement. It would not be enough were the partial performance also to be explicable for some other reason which does not involve a contract having been entered into. In this case, the alleged part performance is not unambiguously attributed to the existence of the alleged 2009 shareholders agreement and cannot be explained only as performance of that alleged agreement. And one would have thought that there will be other passages in other cases to similar effect.
Yeah, the ones I was thinking of were probably the ones that cases about whether it's necessary to imply a contract. I mean, that's the where it is said there must have been a contract between us, and so it's the question. It's the cases of implied contracts that I was thinking about, which actually is dealt with in Chitty at 4-209,
right?
Where I mean, simply as I've just indicated, there's a raft of cases referred to that simply say that the contracts are not likely to be implied. The courts must be able to conclude with confidence that the parties intended to create legal relations, or that it must be necessary to imply a contract. So, I mean, I think that the point that I've always understood is if somebody says there must have been a contract between us, given the way we both behaved, if in fact your behaviour can be explained in a way which doesn't involve a contract between you, it is not necessary to imply one. There is, I think, in this particular case, the judge appears to work on the same basis. He's saying, as I understand it, it's not necessary to conclude that CCLP LLP was party to a contract with Soc Gen, because the fact it chose to abide in its billing practices by the contract that had been entered into between Europe and Soc Gen it doesn't necessarily mean that it intended to be bound by that contract or to become a party to it. It simply was, if you like, avoiding embarrassment for its French counterparty, or because as a group it was commercially sensible for them not to cut across what had been negotiated between Europe and Soc Gen. That's what I understand the judge to be saying in that very condensed way.
Indeed. It's related to other points that are made in Maloney Friend's skeleton, to the effect that if Clifford Chance LLP and other Clifford Chance entities weren't bound by these agreements, somehow it would be, well, I think he said absurd below, somehow it would leave Soc Gen with an agreement of very little value. Now, we don't really understand that point. I haven't developed it because it's a point that wasn't raised and wasn't pursued by my friend this morning. But all we're really talking about, what we're talking about here, is where should this litigation, we're talking about here 2 stages. One is you enter into the framework agreement on his footing in binding Clifford Chance LLP, on our footing not. You then enter into the implied retainer, in which there's every opportunity to both parties to settle the terms on which they propose to proceed. And secondly, the only thing we're really talking about in this case, or the central thing we're talking about in this case, is, and the judge deals with this, is whether or not Clifford Chance LLP and all other Clifford Chance entities in the world would agree, were likely to agree, did agree to being bound by a French law clause and a French law and a French jurisdiction clause. And in the context of weighing up the probabilities, as the judge did and said he did, that's fundamental, we submit. So, my lord, I've reviewed my notes on ground 1, and subject to any further questions that your lordships may have, I propose to move to ground 2.
Yes, please.
Ground 2, we deal with in some detail in our skeleton at paragraphs 39 and following, page 138 of the core bundle. And as Mr. Chapman acknowledges, the 2 points that weighed very heavily with the judge when he was applying the Donoghue and Armco test were, 1, the potential fragmentation of proceedings, and 2, which we submit has to be fundamental, the question of whether there really is or was any pleadable, sustainable, pursuable claim on the part of Soc Gen against CC Europe. And that point is, we submit, unanswerable. Once one finds, this is a conclusion for the open to the judge to reach on the evidence, that not only can he not see the basis of a claim against CC Europe, but what is more, a claim against CC Europe is not spelt out, the nature of the claim, in any submissions or in any evidence or anything of that sort. What, applying the discretionary common sense approach that the judge is entitled to take to the question of whether there is strong reason in Donoghue and Armco context, what else on earth should he or would he be doing? Why would he be essentially assigning a case for which no substance has been put before him to be litigated in France at the expense of obvious fragmentation of the proceedings?
But he wasn't being asked to stop the proceedings carrying on in France, was he?
They were only just started just
They'd only started. He wasn't being asked to stop the proceedings. No, there was no application for an anti-suit injunction. What will happen to them will be decided. Parties will have to decide what they want to do in the light of your lordship's judgment.
But at the time of the hearing before him, they had been commenced.
They had been commenced. We don't know what they said, or at least we've got no evidence before the court as to what they said. It's not being suggested by my learned friend, as it wasn't before the judge, or rather, the basis of the claim that might be made against CC Europe is not spelt out, wasn't spelt out then in any way. All that's been done is reference back to the 23rd of February 2022 French letter before action. Now, one would expect, if it's to be said that there is substance in it, there's something that should go to trial in Paris, one would expect to have that explained. And all that's happened today is we've had some remarks, and I mean this respectfully, some remarks about what the term dominus litis in the letter of the 23rd of February might actually mean. It is noticeable that when one looks at that letter, page 197F in the supplementary bundle, you had been, it's addressed to Europe, copied to LLP. You had been managed to conduct as, you've been mandated to conduct as dominus litis adequate proceedings against 4 entities of the Goldas Group, and so on. So the assertion there seems to be that you, Europe, were instructed to act in the Goldas litigation, and whatever dominus litis might mean, that is the basis on which we make this claim against you. So we heard from the learned friend this morning about what it might mean to do with there being some sort of supervisory role that, notwithstanding Clifford Chance LLP's role in actually handling the litigation, imposed some sort of obligation on CC Europe. We don't have a clue as to where that actually came from. It seemed to be, with great respect to my friend, it seemed to be a large degree of speculation built into it. The point is this, 2 things to say about that, apart from what I've already said. One is that it was in fact Clifford Chance LLP who conducted the litigation. It's not being suggested in this letter at any rate that more than one firm conducted it. And secondly, of course, the judge has found and reviewed the evidence and found on the basis of the evidence that the party instructed was Clifford Chance LLP under the implied retainer. So it's really very hard to see how it can be said before the court today that there is, absent some more evidence, absent some more explanation and so on, that there is a claim against CC Europe. Now, going back to the basic test, it is worth reminding us of the instructions that the judge gives himself. At I'm looking for the passage in Briggs. Give me a moment.
It's 111. It's 111 where he talks about bricks. It's 78.
Yes, it's paragraph 78 of the judgment at page 66. And this summary is not challenged by the appellants. It's after reference to Donoghue, and we're all aware of the strong reason test. And Briggs explains it in the following way: in the context of genuine multipartite litigation, where some but not all of those genuinely involved in the dispute are party to the jurisdiction agreement, the jurisdiction agreement may not be given effect, even if it is for the English courts, as was confirmed by the House of Lords in Donoghue and Armco. Although there may be a contractual agreement on jurisdiction, this will not be specifically enforced, where to do so would fracture the coherent adjudication of a multipartite dispute. Of course, the potential for abuse of this principle is understood, and if a court believes that non-parties to the jurisdiction agreement, affiliates and subsidiaries, or friends of the relations having memorably described in Donoghue and Armco, have been put up to litigate by one party in order to contend that they were not bound by the jurisdiction agreement, with a view to fabricating an exception, a court should detect it. Where there is no such manipulation, the existence of a jurisdiction agreement is strongly indicative, but is not conclusive on the question of whether relief will be ordered. So the focus here is on, in that passage at any rate, is on fragmentation. And as I'll show your lordship in a moment, fragmentation is regarded as an aspect of avoiding it because it is not in the interests of justice overall that there should be fragmentation.
The sense of fragmentation was introduced by your CCLP deciding to issue proceedings for a declaration in the UK. I mean, if you receive the letter says we're going to we contend that the two companies, LP and Europe, failed in their duties to us, Soc Gen. Undoubtedly, Europe has entered into a jurisdictional agreement with Soc Gen. Why didn't Clifford Chance LP tag along and have the thing heard in France?
They didn't contend that the letter is addressed to CC Europe in the first place.
Well, both.
As well, it's copied to CC LLP. It's the allegations are made so far as CC Europe's conduct in litigation is concerned. But in any case, we did the sensible and correct thing. As the judge has found, and we haven't had to look at it because there's no challenge to his decision on forum non conveniens. As the judge has found, he not only found that the appellants now have not established that France was clearly and distinctly the more appropriate forum. He finds, and we can turn this up, at 120, page 79 of the judgment, that this court, I'll read it, consequently it has not been shown that the courts of France are clearly and distinctly the more appropriate forum. To the contrary, this court is that forum. So make no bones about it. We strongly take the view that the litigation should take place here. And indeed, anyone looking forward from the retainer was made, or for that matter, any of the framework agreements were made, might well expect that anyone who was not bound by the jurisdiction clause would wish to litigate in their home jurisdiction. And what's more, if the litigation was so closely connected as this one is to a particular jurisdiction, would want and expect it to happen there. So, yes, we have brought matters to a head by starting proceedings here, but that is for very good reason. And putting aside the jurisdiction clause, the judge has found that there is very good reason for doing so in his decision on forum non conveniens, having found that CCLP is not party, or at any rate, that we have the better of the argument CCLP is not party to the jurisdiction agreement. Well, a causative point is made that the fragmentation only occurred when Soc Gen issued in France, which was more than a year after we issued this claim. And Mr. McWilliams reminds me on that footing of the sensible point that on that chronological footing, it can hardly be said that we have caused the fragmentation. In other words, we were, by beginning proceedings here, we are of course inviting them, insisting on them. They disputed it, at least inviting them to have the litigation tried here in a non-fragmented form. So as Mr. McWilliams rightly reminds me, it's very hard to see that we can be held to have caused the fragmentation.
The point made against you by Soc Gen at 49 of their skeleton is not so much who caused the fragmentation, as whether it was foreseeable.
I'm going to deal with that point. In fact, that's the point I was about to come on to. We respond to the fragmentation point Give me a moment. At paragraph 45 of our skeleton, and we say two things here, and I'll develop them both in a minute. Paragraph 140. There is no rule that a stay must be declined if the possibility of fragmentation was foreseeable at the time the exclusive jurisdiction clause was entered into. We say no such limitation was imposed in Donahue, and the authority on which Soc Gen relied at Concola doesn't have that effect. And we cite the passage from Concola. I'll be taking you to the case of Zephyrus in a moment, which assists on the same point. And we then say that the fragmentation about which the judge was rightly concerned in this case was in the event not reasonably foreseeable. The issue here is not that multiple Clifford Chance entities have been instructed in relation to the same case, with some bound by the exclusive jurisdiction clause and some not. It is that a single Clifford Chance entity, CCLLP, was instructed in relation to the Golders litigation and is not bound by the exclusive jurisdiction clause, that the complaint relating to that instruction has been wrongly directed to an entity that is bound, namely CC Europe. So that's what we say in our skeleton. And just developing that for a minute, I would like to take your lordships, if I may, to the case of Zephyrus, which is in the original authorities bundle at tab 4. This is another decision of Mr. Justice Henshaw. And if we go to page 111 at paragraph 114, we can see what's said. He's been through a large number of authorities at paragraph 125. Excuse me. And he says the authorities which he's just summarised, taken as a whole, support the following propositions relevant to whether the prospect of an unfair trial in the court chosen in an exclusive jurisdiction is a strong reason to decline a stay of English proceedings, or mutatis mutandis, to decline to restrain proceedings abroad in breach of an exclusive jurisdiction agreement. The court is not bound to grant a stay but has discretion to do so. We know absolute or inflexible rule governing the exercise of the discretion. English court will ordinarily exercise its discretion by granting a stay of proceedings unless the claimant can show strong reasons for suing in England. What constitutes a strong reason will depend on all the facts and circumstances of the particular case. The burden of showing strong reasons is on the claimant. Strong reasons are not shown merely by establishing factors that would make England the appropriate forum on a forum non-conveniens analysis. And then this, 7, foreseeable factors of, quotes, mere convenience should not be regarded as strong reasons to decline a stay. See the cases referred to in paragraphs 114 to 115 above. And our essential point on this, I'll develop it a bit more in a moment, is that questions of fragmentation are not questions of mere convenience. Problem with fragmentation is the interests of justice, and that it impedes, doesn't promote the achieving of a just result. And then we see at 8 over the page, regard may be had to whether the claimant would be prejudiced and so on. And then at 9, there are some judicial statements suggesting that even a matter pertaining to the interests of justice might not amount to a strong reason if it was foreseeable and could be regarded as encompassed within the parties' bargain in agreeing to the jurisdiction clause. However, the preponderance of the cases treat the interests of justice differently in that regard from factors of mere convenience. And by mere convenience, what the courts are clearly talking about, and it's covered in the cases that the judge here has just referred to are matters such as the location of documents, witnesses, likely speed of litigation, and so on, all the sort of things that come up in a forum challenge. And then at 117, well, what's happened is that at 117 to 123, the judge has reviewed all those authorities, on the basis of which he reaches the conclusion that mere convenience, or rather fragmentation, is not a matter of mere convenience. It goes to the interests of justice. And we see the summary I've just taken your lordship to at paragraph 125. And then if we go, please, well, we'll come to how it goes. And what happened in the Zephyrus case is that the defendants sought to suggest that fragmentation was foreseeable and so not a good reason. And on the facts of that case, that was held to be, so we see this at 494 to 494 to 498 of the judgment. And picking up at 497, so far as concerns the LP claim specifically, it's true that the multiplicity of proceedings can be traced to an original contractual structure, in the sense that the LP policies are subject to English jurisdiction, whereas the claimants left the jurisdiction provisions of the OP policies to be determined by the lessees, and so on. So on the facts of this case, the judge decides that in the circumstances, the prospect of multiplicity of proceedings and the resultant risks of inconsistent findings on key issues, though not decisive, are factors that can properly be taken into account. Our point is essentially this, that in general, risks of fragmentation goes to the interests of justice. That's not a matter of mere convenience. What the foreseeability point is concerned with is questions of convenience that we're all familiar with. And we'd add this, that in any case, we say it's not foreseeable that Soc Gen, which would wish to pursue an entity, CC Europe, which on the face of the evidence before the court is not said to have done anything wrong. What one's concerned with here, if foreseeability has anything to do with fragmentation, is the point that on matters of mere convenience, we can't rely on things that should have been foreseen at the time that the original contract, the original arrangement was made. Well, it was not, it isn't and wouldn't be foreseeable that CC Europe should be pursued in the absence of some sustainable claim being identified.
So you're actually focusing on, to go back to paragraph 25 of Zephyrus. You're saying it has to be both foreseeable and could be regarded as encompassed within the parties' bargain in agreeing to the jurisdiction clause. So you say, well, Europe agreed to a jurisdiction clause, which would be perfectly understandable and shouldn't be ignored if the dispute actually related to the provision of services by Europe, for example, to Soc Gen, obviously. And if they were, for example, providing some services in conjunction with another Clifford Chance entity in another jurisdiction, the fact there might be fragmentation in those circumstances is what is within the encompassed within the agreement by Europe to the jurisdiction clause for France, because in a sense that's France, they've decided that's what they want. But I think you're saying where there is no obvious basis for thinking that Europe did provide any of the services which are said to be the subject of complaint, it's not really within the basis for which they've agreed to the jurisdiction clause.
No, but that's precisely it.
Well, isn't there a simpler point to be made here, which is that the court has decided that this jurisdiction is the natural, convenient forum for the claim against
Indeed.
CC LLP in relation to its conduct of the English proceedings and the allegations of negligence. It appears that what SocGen wished to do is to sue CC Europe in relation to the same matters. The conduct of the English proceedings by Clifford Chance LLP in this jurisdiction. Now that is inevitably going to, if those proceed in Paris, that will inevitably drag LLP into those proceedings to defend them on a parallel basis. And you will then have not just fragmentation, but you'll have complete duplicity.
Indeed.
And there's strong reasons why, particularly if the claim against Europe is a duplication of the claim against LLP, why all of that should be dealt with in one jurisdiction, which is here.
I've jumped over our main points, but your Lordship exactly had it. One can have a look at the way in which Lord Bingham puts it in Donoghue and Armco, and it precisely matches. It's to do with the overall interests of justice, avoiding duplication, avoiding inconsistency. And as I say,
It'd be nonsense, wouldn't it, if we and we could even have a situation where you had different results on the two claims, all related to exactly the same subject matter, namely, was there negligence in the conduct of the English proceedings?
I didn't wish to understate the importance of fragmentation, but this case has an additional factor which isn't present in the other cases, as far as I know, that the claim against the basis for the claim involving the other party is not identified.
Well, and to the extent that it is the negligence of CCLLP.
I'm not sure Maloney Friend would accept that, but it has to be, yeah.
Well, that's what's in the letter. Yes, thank you.
Nothing more to add, Lord.
Thank you very much.
Well, briefly, if I may, and as my Lord will expect in reply, Malone Friend began with something about the timing points, which I'll have to turn, but that in itself goes to the point my Lord Justice Phillips was making, of course, in Malone Friend's argument, as to the presumption that arises in our submission from the clear wording of the later framework agreements itself, and the way in which we say the judge failed to give due weight to that wording in paragraph 104 of his judgment at page 74 of the core bundle. True it is that the judge makes passing reference to the wording and comments that it might be said that lends a veneer of support to SocGen's position, but he does not actually give due regard at all, we would say, with respect to what the clear wording of the contract says. In that regard, Lord Justice Zacaroli said during the course of Malone and Friends submissions, or rather drew attention to the third sentence of paragraph 105 of the judgment at page 74 of the core bundle, which is where having found that it was improbable that CCLLP would have given authority to Europe to bind it without some careful vetting process, and we'll have our submissions on that. He goes on to say, more plausibly, CC Europe may have taken the view that by stating it was acting on behalf of all offices of Clifford Chance, it was confirming as in the judge has found in the case of previous framework agreements, it was itself agreeing how matters would be handled both in its own and in CCLLP's various offices, as opposed to directly binding CCLLP. Well, there again, which is why we made the attack on the basis that we did, with respect, the judge simply fails to give due regard to the words, that the words are far more consistent with our position, that they mean what they say, and that Europe was binding and contracting on behalf of CCLLP, rather than indicating some loose aspiration that it would seek to ensure that CCLLP would comply with the terms of the framework agreement. And of course that in turn turns into the inherent probabilities, as my lords identified is our position in the course of my learned friend submissions. It is, standing back, far more likely that Europe had authority, as it said it did, to contract for and on behalf of CCLLP, than that they did not do so. And it is, we would say with respect, pretty extraordinary for a global law firm such as Clifford Chance to adopt the position that one of its offices, one of its larger offices in Paris, could effectively do what it now says it was doing, namely say it was contracting for on behalf of CCLLP, the largest of the CC entities with the offices throughout the world, when in fact it had no authority to do what it says it was doing, and what the judge implicitly found it said it was doing, namely to contract and bind CCLLP, such that after the event, CCLLP can, so to speak, click its fingers and say, technical knockout, in fact, CC Europe did not have that which it said it had, namely authority to bind us, and therefore we are not bound. And my lord, that does tie in with the timing point, because the reason I made the timing point was because of the implicit criticism, or at least commentary, on SocGen's evidence in paragraph 103 of the judgment at page 73 of the bundle. And here the learned judge was dealing with the position of actual authority, and he identifies that SocGen in its evidence, and in particular Mr. Fowler's second statement, summarised the French law principles of agency, but without making any positive assertion that CC Europe had CCLP's actual authority to bind, nor that SocGen had any specific state of mind or belief about any such actual authority. And he then makes the observation, it was perhaps not surprising, that CCLLP's evidence from Mr. Parry on the question of actual authority is, quote, relatively concise. Well, my lords, as I sought to explain this morning, the authority point was not taken because of the wording of the contract. It said on its face that CC Europe had authority to bind CCLLP. And no point was taken about that by Mr. Hewitson in his evidence. And I perhaps just should show my lords this, because I made reference to it without turning it up. In the supplemental bundle, tab 14, page 216. And it's paragraphs 27 and 28, and perhaps I'll just invite my lords to read those paragraphs, please. So, my lords, what Mr. Hewitson was saying in answer to the application was not that Clifford Chance LLP was not bound because CC Europe did not have authority to bind it, Clifford Chance's first answer was to say that that's not what the contract said. That the reference to, in its own name and on behalf of the offices of Clifford Chance LLP, was not to be read as a reference to CC LLP at all. Now, if it really was going to be said by Clifford Chance that contrary to the wording, the express wording of the framework agreement, CC Europe did not have authority to bind CCLLP, you would with respect have expected it to have appeared in Mr. Hewittson's statement and to have appeared here. And yet he does not mention authority at all. Now what then happens is, as we've seen, Soc Gen adduce evidence as to the French law of agency. And it's in response to that that Mr. Perrin says, dare to speak, playing his joker, oh no, in fact, there's no authority provided by CC LLP to CC Europe after all. And with respect to the judge, given that history and given also that evidence as to CC LLP's provision of actual authority to CC Europe was entirely within the gift of Clifford Chance, difficult to see on what evidence Soc Gen could adduce on actual authority. Apparent mandate, I accept, is different, but on actual authority, it's very difficult to see what evidence Soc Gen could have produced. And yet all we have from Clifford Chance is, first of all, Mr. Hewitson not raising the point, but raising others. Then Mr. Perrin, with his very short statement, the shortness and brevity and inadequacy of which is not addressed with respect by the judge's observations in paragraph 103. And that then has to be weighed against the overall probabilities and, in particular, what the contract actually says.
I'm not sure what the timing point is. Are you saying that in some way Mr. Perrin's evidence can be regarded as less credible because it was produced at the point it was?
Well, I think what I'm saying is that the judge sought to dismiss the criticisms that we made as to the brevity of Mr. Perrin's evidence and the various lacunae in it that I identified this morning on the basis of, well, it needed only to be very short because Soc Gen had not itself led evidence as to actual authority. And the answer to that is, well, the judge was simply wrong about that in his analysis, because to the extent that it was ever for Soc Gen to lead evidence on actual authority, it's difficult to see what evidence it could have led. But in particular, this point as to the absence of actual authority seems to have been something of an afterthought. And when you then take that into account, alongside with what we say with respect are the inadequacies in that evidence, when balanced against what
there could have been evidence as to the negotiations at the time of the entering the 2012 framework agreement, which demonstrated that Clifford Chance LLP were involved in that process in some way.
Well, perhaps, although that perhaps more directly goes to the question of apparent mandate. In terms of...
Well, even if they'd been involved in its negotiation, it probably would have been quite difficult for them to dispute that what was said was... I mean, it may be that even travelling drafts went to different offices. I mean, there's just nothing from your clients at all about how that agreement came to be made.
Well, my lord, no. But then one perhaps goes back to, unless and until actual authority is put in issue, and it wasn't until after effectively our evidence is closed, that's the timing point. But beyond that...
Well, it's over 2 months before the hearing.
Well, I accept that.
Paragraph 47 is the one we were taken to, in page 225, where CCLLP says it's not a party to the framework agreement. Well, you don't need to do very much by way of addition to put 2 and 2 together and figure out that if they're saying they're not party to the framework agreement, you say the 2012 framework agreement says it's entered into by Europe on behalf of CC LLP, that agency just might be an issue.
Well, except that that paragraph 47, is in the same witness statement, where the only basis upon which Mr. Hewitson says that CCLLP was not a party is not because of any lack of authority on the part of CC Europe, but relying on the terms of the contract. But anyway, my lord, that's an answer to the timing question. In terms of implied retainer, we do say, with respect, that that's an aspect of the being bound by conduct argument. It is not, with respect, a point about whether by acting consistently with the terms of the framework agreement, a contract can spring into being from nothing. It's accepted that by both parties that there was a contract between SocGen and CCLLP on the assumption that it was an implied retainer. The question then is what are the terms of that retainer? Not whether it existed, but what were its terms? And then one looks at what evidence there was for the terms, and contrary to Malone and Friends submission, there was evidence as to what the terms might have been, and that evidence was that CCLLP, in fact, operated the contractual machinery under the framework agreement by charging as it did, reporting as it did, and so forth. And so we say, with respect, Malone and Friend is wrong to say there was no evidence as to what the terms might be. There was evidence. And again, one asks, what's more likely? What was CCLLP operating the framework agreement, as the judge appears to have found, in order to ensure that CC Europe did not act in breach of the CC Europe framework agreement, or was it operating the contractual machinery because those were the terms of its retainer? And we say the answer is obvious and was overlooked by the judge. My lords, finally on ground 1, paragraph 87 of the judgment, there's not much more than I can do than say that we, and with respect it seems Lord Justice Mayles, read that paragraph differently to Malone and Friend. 4 bundle, tab 5, page 69. We understood the judge to be saying, and understand the judge to be saying there, that it was the intention of the SocGen entities and the Clifford Chance entities that the work done by Clifford Chance entities for SocGen entities would be performed throughout the world on the terms of the framework agreement, but that the judge went on to find that there was no indication that that intention extended to binding Clifford Chance entities other than Clifford Chance Europe to the terms of the framework agreement. But other than identify that is our submission, on paragraph 87, and of course inviting my lords to read the paragraph again, I can't take that any further. My lords, on ground 2, first of all, the points made about the absence of a substantive claim. What matters is that a claim is being brought, and it would be inappropriate, and the judge was wrong in our submission, to form any view as to whether a claim in substance as a matter of French law was or was not being brought. The claim is being brought. It forms to be judged as a matter of French law and adjudicated upon as a matter of the exclusive jurisdiction clause by the French court. It is, with respect, somewhat perverse to try and criticise SocGen having been, so to speak, dragged to this jurisdiction contrary to the terms of its bargain with CC Europe for failing to spell out in granular terms the claim that it actually is bringing and now is bringing in France.
But the question of what the claim is must be relevant to this issue, because if in fact the claim is purely duplicative in the sense that I think, as you put it to us earlier, it's really just the UK didn't do its job properly because it was instructed, and in some way Europe didn't supervise it, then the claim is it's one and the same claim in truth. If for example, the claim of Europe was a very different claim, such as, well, it's a breach of warranty of authority claim. You signed the 2012 agreement purporting to act on behalf of LLP, and in fact you didn't. And so we'll bring a claim against you for breach of warranty of authority in entering into that agreement. It's quite different.
That might be a claim that's brought.
Then you could see that there would you could indeed, but you could see then in the sense it would be within the scope of the jurisdiction clause to have the Europe claim heard in France.
My lord, as a matter of principle, I don't disagree with any.
So it does actually matter what your claim is, and all we've got is the letter, which seems, to the extent we can make something of it, seems to have no separate role at all for Europe, other than being lumped into the same dominus litis, whatever it is, with the actual firm that was conducting the litigation, namely UK LLP.
No, my lord, as a matter of principle, I don't disagree with respect with any of that, in the sense that I, of course, accept that the nature of the claim is relevant to the next point when it comes to the exercise of discretion as to whether fragmentation, the risk of inconsistent decisions and so forth. But just dealing, because the judge founded his conclusion on two bases. The first was, there's no substantive claim at all. And we say with respect, he was just plain wrong about that. A claim is being brought. It may yet prove to be good or bad as a matter of French law, but whether there is or is not a substantive claim was something where the judge got it wrong. There is a substantive claim being brought. It was articulated for good or ill in the demand. It's now being brought by way of formal proceedings.
Is he not entitled to evaluate, having looked at the demand, whether it is a substantive claim? Because that's all he had. The only evidence he had, he didn't actually put the French proceedings in front of him, as I understand it.
No, they weren't. That's right. They were not.
So all he's got is that letter, and the letter seems to treat Europe as if, for some reason, Europe was actually conducting the English litigation. The only.
And my lord, I can't go beyond what I've said this morning. Because it's a claim that's governed, as articulated, governed by French law, and it may look very strange to us, but there it is. But in terms of the first reason that the judge gave, no substantive claim, therefore good reason, that's a bad reason. As regards his second reason and the risk of fragmentation, the overarching point is that Soc Gen is entitled to the benefit of its bargain. It bargained for an exclusive jurisdiction clause. It is being sued in breach of contract. I think that's almost implicitly accepted by CC Europe. By CC Europe bringing the proceedings here. And what may be more important with respect is that CC Europe is seeking substantive relief in this cause, contrary to the bargain that it made, namely that it would only bring proceedings in the High Court of Paris. And that, I think, does bring me to my last point, which is on Zephyrus, which is, my lords will no doubt consider this in due course, but it's quite a lengthy passage that leads up to paragraph 125. And the real issue in Zephyrus was whether the risk of the parties not obtaining a fair trial in Russia was foreseeable, and even if it was foreseeable, whether that was something that weighed in the balance. That was the interests of justice point, and that was the point of distinction really being drawn by points of substantive justice. Namely, it didn't really matter whether it could have been foreseen at the time the jurisdiction clause was bargained for that there may be problems with obtaining a fair trial in Russia, and other matters labelled as matters of convenience, where if they were foreseeable at the time the parties entered into their bargain containing the exclusive jurisdiction clause, then they do not weigh in the balance and do not constitute good reason for refusing a stay in contravention of the terms of the exclusive jurisdiction clause. And my lords, just briefly, one sees that what we would describe as an orthodox position in Zephyrus at paragraphs 484 and 486. 484 is at page 199 of the authorities bundle. And my lords will just see there that the learned judge, by reference to the case of Lungo and Vedanta, identifies that a risk of irreconcilable judgments may have less or possibly no weight if it was self-induced by the party asking the court not to give effect to the exclusive jurisdiction clause. And 486 makes the point that fragmentation is not uncommon in multi-party situations, and generally speaking, that will not constitute good reason to not give effect to an exclusive jurisdiction clause for which the parties have bargained. The law's just give me one moment. I'm grateful for indulgence, my lord. Is there anything else that I can try to assist my
Just
lord?
one question are you obtaining a transcript of today?
Yes, we are. Yes, we are.
So,
And we'll make sure that that's provided to the court in the usual way.
yes, thank you very much. Well, thank you to both parties for their submissions today, both counsel who've addressed us, those behind them, counsel and solicitors, very grateful. We'll reserve judgments and they will be provided in the usual way in draft. You know the restrictions both on their use and on the comments that you can provide on them, just typographical errors and obvious errors, please. We then ask you to seek to agree order in between yourselves, and any consequential matters that need to be debated in writing, please. And then the judgment will be handed down electronically.
Very well.
Thank you very much.